Hi, my name is Jeff Morgan. I'm from Dallas, Texas, and I'm going to continue on the topic that I started last time, the Board of Trustees of Dartmouth College versus Woodward. This was a case that took place in 1819. At stake was an issue of whether the legislature of New Hampshire could impair a contract that was made between the King of England and the trustees of Dartmouth College. The King of England granted a charter to Dartmouth College in 1769 before our Constitution was written and adopted. The terms of the contract said that Dartmouth College would remain in the hands of the trustees of the college and that the college would be a private college. The state of New Hampshire said, we want the college to be a public college. The trustees of Dartmouth College sued, and the case went to the Supreme Court. The Supreme Court agreed with the trustees by a vote of 5-1. 5-1, they agreed that the state of New Hampshire did not have the ability to impair the contract, to weaken, to destroy the contract that was the private contract, the civil contract that was contracted between the King of England and the trustees. In his opinion, he wrote that the framers of the Constitution did not intend to restrain the states in the regulation of their civil institutions. The Chief Justice said, yes, the legislature can regulate civil institutions, but what he is also saying is that according to the contract law clause, in which no state shall pass a law that impairs the obligation of the contract, that the state legislature did not have the authority to violate that contract. Their powers to abrogate that contract or to impair that contract were restricted by the Constitution of the United States. He did mention that there are some acts in which tribunals may act on behalf of the parties to a marriage contract and may grant divorce. But his argument is not that these divorces happen willy-nilly or without cause. The reason that the tribunals could actually grant divorces was because there was a breach of contract. A breach of contract by one of the parties. It was never a no fault. It was never a no unilateral divorce. It was always that one party had breached the contract and divorce was the remedy for the breach of the contract. Every contract contracted between businesses, between individuals, in most instances they have two parties, sometimes more, and each party has an agreement, something that they have to perform in order for the contract to remain valid. If I am going to pay somebody so much money and he promises to do work for me, I pay the money and he does not do the work, I have the right to sue him. On the other hand, if he does the work and I don't pay him, he has the right to sue me. In either of these two cases, there is a breach of contract in which the judges would get to, in which the court would get to hear who was at fault, who breached the contract, who owed whom compensation for the breach. So tribunals or courts were established because the marital contract had been broken. Tribunals were not established in order to grant divorce without the breaking of the contract. When any state legislature shall pass an act annulling all marriage contracts or allow either party to annul it without the consent of the other party, it will be time enough to inquire whether such an act is constitutional. In other words, what Chief Justice Marshall is saying is that fault-based divorces are fine. Unilateral, no-fault divorces are not. When the state legislatures pass laws that say you can get divorced for any reason or for no reason whatsoever, no fault has to be found, no breach of contract has to be found, you get to divorce another person at will, divorce on demand, and the respondent has no defense and loses 100% of the time, we need to inquire whether such a law, such as we have in the state of Texas, is constitutional. Chief Justice Marshall writes further, in a legal sense, all contracts recognized as valid in any country may be properly said to be matters of civil institutions, since they obtain their obligation and their construction in the place in which the contract was made. So if you have a contract, it does not make a difference what kind of contract it is. If you have a contract in a legal sense, a contract is a contract is a contract. There is no difference between a marriage contract and some other contract. If you want to sue for breach of a marital contract, you can do so. But you can't sue to get out of a marital contract when there is no breach committed by the other person. And yet that is exactly what unilateral divorce, no-fault divorce, permits. Chief Justice Marshall of the Supreme Court in 1819 states that such acts as this are unconstitutional. He continues, a general law regulating divorces from the contract of marriage, like a law regulating remedies in other cases of breaches of contract, is not necessarily a law impairing the obligation of a contract. It, that is divorce, may be the only effectual mode of enforcing the obligations of the contract on both sides. A law punishing a breach of contract by imposing on a person a forfeiture of the rights acquired under the contract, dissolving it because of the mutual obligations which were no longer observed, is in no correct sense a law impairing the obligation of the contract. What he is saying is that if you have laws permitting divorce, there's not a problem with that so long as divorce laws are based in breaches of the marital contract. What he's also saying is that no-fault divorce, unilateral divorce, forced divorce, imposed divorce, state legislative divorce are all unconstitutional and should not be recognized. What he's also saying is that divorce is a remedy, and divorce is a remedy. When two people contract to be married, they expect to have certain obligations to each other, sexual faithfulness to each other, the obligation to provide for each other, the obligation not to beat the other person up. Cruel and abusive acts should not be permitted to take place against the party to the marriage, the marital partner that you are with. These are issues that are fault-based for which you can file a divorce. A divorce filed against a partner just because I'm not happy today, or because I met somebody new and I would much rather be with her, or because I'm really upset because you didn't buy me this diamond ring that I wanted. Reasons like that, or even more trivial than that, or even made-up reasons, are not permitted for divorce. If the argument means to assert that the legislative power to dissolve such a contract without any breach on either side, against the wishes of the parties, and without judicial inquiry to ascertain a breach, I certainly am not prepared to admit such a power, or that its exercise would not entrench upon the prohibition of the Constitution. Supreme Court Justice John Marshall said that if you have a legislative divorce, such as we have in the state of Texas, under insupportability, no fault necessary, no breach of contract necessary, it can be a divorce imposed on me or upon another person against my wishes or her wishes or his wishes, that is an abuse. Thus far, the contract of marriage has been considered with reference to general laws regulating divorces upon breaches of that contract. But, and here's where he starts to address the issue of unilateral divorce. If, under the faith of existing laws, a contract of marriage be duly solemnized, or a marriage settlement be made, and marriage is always in law a valuable consideration for a contract. So we talked before about the offer and the acceptance and the consideration. Marriage is always in law a valuable consideration for a contract. It is not easy to perceive why a dissolution of its obligations without any default or assent of the parties may not as well fall within the prohibition as any other contract for a valuable consideration. In other words, what he is saying, though he did not write in these terms, unilateral divorce, forced divorce, imposed divorce, legislative divorce is constitutionally prohibited. It is a violation of the Constitution. It is a violation of the powers of the state that has breached the limits imposed upon them by the Constitution of the United States. A man has just as good a right to his wife as to the property acquired under a marriage contract. He has a legal right to her society and her fortune, and to divest such right without his default and against his will would be as flagrant a violation of the principles of justice as the confiscation of his own estate. And now I'll read that in modern day terms so that doesn't sound sexist. A woman has just a good of right to her husband as to the property acquired under a marriage contract. She has a legal right to his society and his fortune, and to divest such a right without her default and against her will would be as flagrant a violation of the principles of justice, as flagrant a violation of the principles of justice as the confiscation of her own estate. We are against such things as civil asset forfeiture, and yet in unilateral divorce, that is exactly what takes place. Chief Justice Marshall in 1819 argued against unilateral divorce, against a person losing half of his or her estate, property, children, against his will or her will when there has been no breach of contract. No-fault divorce, unilateral divorce, permits this to take place. Breach of contract isn't even inquired into anymore. The entire law is unconstitutional. However, he said, I leave this case to be settled when it shall arise. I have gone into it because it was urged with great earnestness upon us and required a reply. It is sufficient now to say that, as at present advised, the argument derived from this source does not press my mind with any new or insurmountable difficulties. So what the Chief Justice said is that at this time, the issue of unilateral divorce did not appear before the court. It should be addressed when it appears before the court. Unilateral divorce, no-fault divorce, became popular, started to become national in 1969 under California, and has now affected every single state in the United States, and including the District of Columbia. I think it is time to have a case taken to the Supreme Court to see whether such laws violate the contract clause of the United States Constitution, Article 1, Section 10, Clause 1, in which no state shall pass a law to impair the obligation of contract. Thank you.